Australia. To help us today, we have a team of great experts. We have Henry from Bentleys, Queensland.
Pleasure to be here.
We have Matt Hudson, who's a senior manager at SV Partners.
Hi everyone, Matt Hudson here from SV Partners. I'm a senior manager in Insolvency and Forensic Accounting.
And Louisa Sidrabat, a director of the Insolvency Department in Vincent's Accountants in Sydney.
Hi, I'm Louisa Sidrabat, a liquidator and bankruptcy trustee.
So Henry, insolvency processes in Australia is not really well known to a lot of clients or viewers. I guess the most common thing that my clients talk about is liquidation and bankruptcy. That's the only thing they think insolvency actually encompasses.
It is a major part of insolvency. It is not the only part of insolvency. It starts with the concept of a bill. It is a statutory demand, really specifically, where you have outstanding bills or whatever it may be. It could be rent, it could be suppliers, it could even be the ATO or even some of your staff. It is a situation that arises when you have way too much liability but not enough assets to pay for this liability. This leads to, as you mentioned, insolvency, personal bankruptcy, or any other form of other insolvencies that we will explore going forward.
Yes, and usually with step demand, it really starts with something really called a letter of demand. It's simply a legal letter that states the circumstances, saying, well, for this reason, you could be you haven't paid the rent, or you haven't paid 6 invoices of the water that we supply to your business. Please pay it within this date. If you don't, then it leads to something called statutory demand. To really explain that more in detail with great expertise is Matt.
So a stat demand is a particular notice or form that someone that you owe money to, i.e. your company owes money to, that can force you into what is called a court liquidation, or in other words, a compulsory liquidation ordered by the court. Now, that form must be it must meet very strict and specific requirements that I would recommend. If you do see something that says statutory demand on the document, and normally statutory demand is in quite a big font, it should be quite clear, that when you see a document that says that you talk to your trusted advisor, someone like MYG Legal, that you reach out to them, even if it's just a demand letter, just to see to see what that could be and how that might impact upon you. Now, when that form meets the certain requirements, you have typically 21 days to respond to, i.e. to apply to court or to pay the debt. But due to the COVID restrictions, the government in March gave, I guess, everyone a moratorium for 6 months. That moratorium means that not until September can any company be forcibly wound up through this compulsory court liquidation process. So once September passes, probably very late September, courts will start being able to wind companies up once they've met certain thresholds and certain requirements. And unfortunately, we are getting quite close to that now. There's, I think, 7 weeks left. It is very, very important that you reach out to your trusted advisor, MYG Legal, talk to them. They'll be able to help you out.
I think one thing, Henry, that we do have to touch on this statutory demand issue is the importance of having your details updated in the company extract.
That is actually very true. I've had situations where this has actually been quite troublesome, that it actually almost led to potential deregistrations of some people.
Or director's penalties.
Director's penalty included. This simply because the relevant bodies, ASIC included, and other people that may be looking for you, have an old address or have old contact details.
Yeah.
It is very important that you update this as soon as possible. You have 28 days since when you first change your address or your contact details. And this must be updated through ASIC. And this can be updated through your lawyer or your trusted advisor or your accountant. who can assist in this process.
And I think this also brings back to, I think, what we've been talking about in several episodes now, which is the importance of having really proactive accountants and lawyers. I do find once in a while that clients rely on their accountants because they thought they were ASIC registered agents, but technically they moved accountants and they realised that their new accountant have been registered as their ASIC agent. So there are a bit of hiccups here and there with regards to that.
All within expectations, but still stress, update your details often and quickly.
Yes.
Louisa, could you please explain what it is and how this works?
Liquidation is a legal process that happens usually when a company can't pay all of its debts anymore and it needs to close down. There are 3 different types of liquidations in Australia. So there is what's called the creditor's voluntary liquidation. This is where the directors and shareholders of a company choose to put the company into liquidation because it can't pay all of its debts anymore. This is the most common type of liquidation. Another very common type of liquidation is a court liquidation. This happens when the creditor of the company puts the company into liquidation through a court process. So if somebody owes you money, you may end up putting their company into liquidation. Sometimes this might be your company, where your company owes other people money that it can't pay, and the other people may apply through the court to try and put your company into liquidation. If you are in this position, it's very important that you seek legal advice from your trusted advisor, someone like MYG Legal, as to whether it's better for you to put your own company into liquidation or to let the court process unfold and let somebody else put your company into liquidation. There's also a third type of liquidation, which is called a members voluntary liquidation, or an MVL. This type of liquidation happens when the company can pay all of its debts, but for whatever reason chooses to go through the liquidation process before the company ends and is deregistered. The most common reason, or a common reason for doing this, is that the company might hold property bought before the capital gains tax was introduced in Australia, and it might want to pass on that company and preserve its pre-CGT status.
There's really 2 levels of this. As we pointed out, there's a company level and an individual level. Now, for a company level, I'll defer to Matt to further explain what these information means.
Yeah, so a company voluntary administration, it started through a resolution from a director or the directors of the company. And what they're effectively resolving there is that the company is insolvent, but they want to put forward either some options to their creditors, they want to save the business, they want to look at some type of restructuring or turnaround that they might be able to achieve. And the process of the voluntary administration is that hopefully for those directors and the company, it doesn't actually have to go into liquidation. It's an option that allows you to go to your creditors and say to them what you're offering or what potential offer that you could put to them. Now, the administration process involves appointing a voluntary administrator, and that person is an independent person who is qualified, has all the right accreditations. My firm, SV Partners, has about 15 of them, and we are able to run those administrations in the eyes of the law. And what happens is for the first month or 2, using approximate numbers, the administrator takes control of your business, the company, and potentially, depending on what is involved, potentially means that the business can continue to trade through the administrator. Not always. Sometimes the administrator can grant the director to continue running the business. And so through that administration, what happens is that the administrator deals with all the creditors, deals with all the employees, deals with all the different government departments, and we carry out a number of investigations. And those investigations is looking at has there been anything in the past that might get unwound in the liquidation or that might be looked at as in bad terms So that might be that you've paid a related party or someone close to you money that they shouldn't have received.
Thank you very much, Matt.
Wow, that's quite detailed.
Very detailed.
And I guess for as much as similar processes are there for companies to do this, there's also a similar process for individuals as well.
Yes, there is a process, very similar process, but not quite the same for an individual business, whether it be a sole trader or any individual-based structure that you may have. Now, for such, I'll defer to Louisa to explain this in more detail.
So there's also a version of this that exists for individuals who are not companies. This is called a personal insolvency agreement or a Part 10. So in this process, what happens is that the individual might have debts that they can't pay, but they don't want to declare bankruptcy because if they declare bankruptcy, that goes on their credit record and that can affect their ability to borrow, for example, in the future. So what happens through a personal insolvency agreement or Part 10 process is that the person might have a friend or family member willing to offer some amount of money to the person's creditors so that the person doesn't have to go bankrupt. So in this sort of situation, the friend or family member doesn't have to offer to pay the debts in full. They just need to offer to pay some amount that they think the creditors will accept, because the creditors will vote on it to see if they find that offer amount acceptable or not. If the offer amount is acceptable, then the person doesn't have to go into bankruptcy. And that amount, even if it's not the full debt for the creditor, will settle their claim as full and final settlement. This means that the person can never be chased for payment of that debt ever again. So what happens is the person's friend or family member will put forward the offer. It's the job of the trustee, so someone like myself, to have a look through and see if this person was to declare bankruptcy, what would their outcome be? Would there be any money for their creditors? Would there not? What's happened to this person's financial situation up until this point, and what would their bankruptcy look like? And then we look at the offer from the friend and or the family member and say to the creditors, as an independent person, we think that it's best if you, the creditors, either accept the offer for the friend or family member, if it's a good offer, or that they don't, if perhaps the outcome from a bankruptcy will be better. However, we do talk to the person going through this process and their friend or family member, so we do give an indication of what sort of proposal is the type of proposal we can recommend to the creditors in order for them to consider if this person can go through the Part 10 process all the way so they don't have to go into bankruptcy.
I love that. That was such a great explanation. But most of all, I love how it helps individuals. I have a lot of clients who come to me and they're really worried about, if they're going into bankruptcy, they won't be able to be a director of a company for 7 years. They will have a bad credit history. But this is the answer to really the concerns that most clients have when it comes to personal bankruptcy.
I completely agree with you there, Sharon. This is a golden opportunity where not only can you restructure while avoiding all those problems, don't have to be declared bankrupt, but can restructure your business into such a way that it is more useful, I guess, in a post-COVID situation, whatever that situation may be.
Yes.
I mean, you and I don't need to explain the concerns that you have regarding the stigma around bankruptcy and other potential issues. I will state though, this opportunity is once off.
Yes.
And in the sense that you can only do this once. You can't do this over and over and over again. In the past, people have done this and exploited this opportunity, should we say, and they actually call it phoenixing. This process is now illegal.
And this is for companies?
This is for companies. They actually issue you for a director's number now from now on. It is now legislated. Yes. So if you do this too often, they will track you down.
Yes.
Now, it's really hard to see how everything like this works and melds together in real life. Look, Sharon, I know you've dealt with a few situations in that utilises voluntary solvency process. Could you perhaps explain to our viewers what that looks like?
Well, we're doing two case-based.
Yep.
One will be a company C and one will be an individual C. And it's a little bit different, I guess, in these circumstances compared to the COVID, which the viewers are probably going through, but we'll explain that and comment on that as we go. Company C was basically a small hospitality business that were doing well and had plans to expand the business. And it was started with a partnership with two friends, which is we see as being common, bit of friction, one goes away. The business owner really relied on their friend to do the administration, the paperwork. And so when he took over the business solely for himself, he realized he was under a huge mountain of ATO debt. And then there was mortgages, there were finances. He was just swimming, and he was so desperate that he came to us and said, I need help. We did try to negotiate with the ATO, but with the time frame that they demanded for us to sort of the client to pay the debt, it was just impossible, which then sort of directed us to voluntary administration eligibility sort of criteria, and we said, can this client be subjected to voluntary administration? But to explain that more in sort of his point of view, because he had the character of the matter, Matt, would you be able to explain your sort of perspective into this?
Yeah, so Company C was a hospitality business, and when it came to me to have a look at the financials and to work out what was going to be potentially the best course of action for the directors and the company, we worked really closely with their trusted advisors, being my fellow panelists here. We looked through the financials and the information that had been presented, and what we worked out quite quickly was that there was a lot of money owed to the ATO, the taxation office, and when we saw that the business was actually viable and it was actually a good business, we asked a lot of questions and determined that it was because of prior accountants and other advisors that the company had fallen behind on its lodgements with the ATO, that it had accrued quite a bit of liability to them. So we had to come up with an option or some options to work out a way forward so that employees could keep their jobs, the business could hopefully survive, and then thirdly, that there could be a return to those creditors that were owed money. And so what we did was SV Partners was appointed administrator of that Company C, and on day one of that administration, we licensed out the business trading to the director's company. And so what that meant was that the business could keep trading, the expenses of doing the administration were kept very low, and on a fortnightly basis, or I think originally in the first couple of weeks, it was a weekly basis. The director would report to us to make sure that it was cash flow positive, that all the employees and that were being paid what they were owed, etc. And so what happened was during the 2 months roughly that the administration went on for, the business was able to keep trading. All the employees were kept on to be part of that business. And so towards the end of that 2-month period, the director then put forward an option or an offer to all of its creditors, and that was done through this deed of company arrangement that I was talking about earlier. So the contribution that was put up was $75,000. Now that contribution, the majority of it went towards paying employees, because employees were owed a number of things, including annual leave and other things, but it also went towards the fact that the business was to be purchased by this new entity. So the new entity got to take the business, the employees, all the employees were paid, and also the unsecured creditors, so your taxation office, some of the suppliers were paid a small dividend to pay some of them out. So that was about 6 or 7 cents in the dollar, I think, from memory. And what it meant was, out of the process, I think we're 18 months later. From what I've heard, the business is still operating. It's still being able to trade. Creditors are now being paid in full. And one of the, I guess, interesting conversations that we had with the ATO, who actually voted in favour of this proposal, was they said, look, we just want to make sure that in the future the business maintains all of its future tax obligations, does all its lodgements on time.
That provided a lot of detail, a lot of that clarity is just that much more clearer.
Yeah, and for company C, it was definitely a lifesaver. And you know, in terms of there was a lot of employment issues, and we were able to really clean that. And now he's able to restart his business in a fresh platform and make sure that he's compliant. And it's been an absolutely amazing process for company C.
We've touched on this, but this is possible also for individuals?
Yes, and this was definitely was really a lifesaver for one of my clients, which we will call individual C. Individual C was someone where he helped a friend out, put his name as a director, because in Australia, to have a company opened, incorporated in Australia, you need an Australian resident to be a director as well. So he gave his name in terms of just paper only on company extract. He was just listed as a director. Unfortunately, with this one, it led to a statutory government body coming after him due to a very notorious incident that was even reported in the media. And
not good.
Not good. And he made choices due to really ill-informed advices, where it almost took to the point where he had to let go of any asset that he had in his name. He made a drastic decision in terms of his businesses as well, which had a very severe impact in his life. And when he came to me, it was about 3 or 4 years later, and he was saying, I want to buy a house, but I have this issue, what do I do? And it was a circumstance, as I said, that involved a statutory body that were coming after him for more than $1 million overall. And there was other creditors that were going after him as well. And we needed the experts to come into this. It wasn't just normal big names that could do it. I really needed someone who understood the complexity of this issue. And Louisa came into this and really worked through the client's individual circumstances, and were able to provide solutions that were really catered to the client. Louisa can definitely explain that more in details, as she was the trustee appointed to take care of this client C matter. Thanks, Louisa.
Yes, so individual C came to us and he had a very large debt owed to a statutory body. He was quite stressed because he didn't have the money and didn't have a means to pay this debt. The statutory body had been looking for him and was trying to make him bankrupt. If he had become bankrupt, then he wouldn't be able to continue being a director of the other unrelated companies that he was a director of. So we sat down with him and we looked at the options available to him. And we spoke about this Part 10 personal insolvency agreement. He also mentioned that he had a friend that was willing to contribute some money to try and help him get out of the situation. But the friend didn't have enough money to pay the statutory debt in full for him. So what we did was we looked at individual C's financial situation. And we said, in the event that the statutory creditor makes individual C bankrupt, this is how much we think they'll get in the bankruptcy. However, the friend was willing to contribute funds more than what that creditor would have gotten in individual C's bankruptcy. So we put together a plan and a report to these creditors, and so that if you proceed to make individual C bankrupt, this is how much money we think you'll get. And if you accept the payment from the friend, this is how much we think you'll get. So in this particular case, the friend put forward a lump sum amount paid right away, and then installment payments over the following 6 months. In this case, the funds contributed were significantly less than the debt owed to the creditor, about 1/10 of the original debt in this particular case. And the amount that the creditor would have received if individual C had been made bankrupt was even less than this. So we recommended in this case that the creditors accept the proposal from the friend. And in this case, they did, which means that the debt was able to be cleared, so full and final settlement of the debt. This creditor can never ask individual C for payment or chase him for payment again, ever in the future. So the debt was sorted. Individual C did not have to go bankrupt. He could continue being a director of the company and conducting the business activities that he was conducting. And the situation was sorted legally and ethically. I do encourage you, if you're thinking about this process, full and frank disclosure helps the process go as smoothly as possible. And it also means then it becomes less stressful for you as you go through the process. So it was a good outcome all around for individual C and the creditor in this process.
As Louisa confirmed, individual C were able to completely clear his debt and prevented the creditors from coming after him for future debts.
And he's not bankrupt.
Yes, and he can continue to operate his business. So fantastic outcome. There were big hiccups in the middle, which I just would like to talk about, which Louisa hasn't mentioned, was that there were a private investigator hired by the statutory body who followed around individual C. Individual C wasn't really truthful to both me or his appointed accountant or Louisa. So when we got served with the private investigator's report, there was a lot of explaining for us to do. Luckily, due to the diligent collaborative teamwork that we had, we were able to resolve the misunderstanding that there were around there. But I think reaffirming Louisa's point, frank disclosure, being truthful. If you can't be truthful to Louisa, at least be truthful to your lawyer and your accountant, because if we know we have methods to protect you or try to, I guess, address it appropriately rather than being served with a private investigator's report.
This sort of touch on a previous topic we talked about openness and discussion with our respective clients. So the more information that we have, the more we can work with and the more we can assist you in whatever situation at hand. Now, we are here as part of your team to effectively make your lives easier. So I will second Louisa's and your opinion again. Disclosure is just very important in what we do. Now, in very broad terms, not only in regards to insolvency, but whether it be legal, taxation, personal, every little thing may count. What I mean, it makes a big difference. If not factored in correctly, can be very, very detrimental to your personal situations.
Yeah, and for insolvency processes, we really do have to have full understanding of anything that you own. Not only you, but your wife, your children, wherever it is, because if there's any transactions that's been given to your family members, really it can be tracked up to 4 years back and retrieved and reversed. So I can't explain the importance of frank disclosure in this insolvency processes. That brings into the most favorite topic that's repeated in every single episode, which is about costs. So Henry, for Bentleys, for liquidation or for voluntary administration processes, how much does it cost?
Now, it does depend on scale and on your personal situation, personal business structure, and a number of other factors. But a voluntary administration usually starts from $30,000 plus GST and up, and involuntary administration usually starts from $10,000 and up. But we are happy to have a no obligation chat to see how much it is for your personal situation and provide you with a proper quote so there is no nasty surprises.
Yes. And what about you, Matt? What would SV Partners sort of cost look like for liquidation and voluntary administration processes?
Yeah, so I guess talking about costs now can be quite difficult because it very much depends on the industry, the amount of information, what's gone on in the past and what result you're wanting hopefully to achieve. Now, typically for an administration, I would have thought starting at say $30,000 is probably realistic, to be honest, on what it might cost, at least on a basic or general administration. And a lot of the reason, I guess, for that is because there are 2 reports that have to be sent out to creditors. There are also 2 meetings of creditors. So it tends to be a lot more hands-on, a lot more information that needs to be released. And you need to compare the scenario from an administration with the liquidation. So there tends to be a lot more involved. Whereas for a liquidation, there doesn't have to be a creditors meeting. There is 2 reports, but they typically, the first report, for instance, is very basic. A liquidation you could probably, typically for a basic one, would be in the range of 10 to 15,000.
What about you, Louisa? What would you say is Vincent's cost for liquidation and voluntary administration process?
Sure. So for our approach, we'll generally quote costs direct for each person's individual situation. This is because the cost can vary quite widely, and it may be a lower cost, especially if it's a smaller company or a less complex financial situation. So what we recommend is book a call with us or something like that. The call's at no cost, and we go through your particular individual circumstance.
I hope you found today's episode very informative. We thought particularly it was very important to get this information across, as the grace period or moratorium is coming to an end very soon. So we have about 7 weeks left now. Although there are talks, as we mentioned before, about it extending, it still doesn't prevent certain organizations from coming after you for their standing arrears. Don't be afraid. If you are in over your head in terms of debt or any arrears, call any of the experts here. Their details are in the expert profile playlist or in our separate videos. Contact them, have a discussion. So thank you for tuning in. Don't forget to subscribe to our channel and continue to get great information that's crucial to run a business or investment in Australia. Thank you.
Thank you.